In this video, I am going to discuss the scope of Section 397 Cr.PC, how the power of revision is exercised, what is interlocutory order, and whether second revision petition is maintainable. Who can exercise the power of revision? As per Section 397 Cr.PC, the High Court or any sessions judge may exercise the power of revision, and how that power is to be exercised. For exercising the power of revision, the High Court or any sessions judge may call for and examine the record of proceedings before any inferior criminal court situate within its or his local jurisdiction. So, while exercising the power of revision, the High Court or any sessions judge may call the record from the inferior criminal court whose order is under challenge before the High Court or before the sessions judge and examine that record. What is the purpose of exercising the power of revision? Whenever any revision petition is filed before the High Court or before the sessions judge, the court in the revisional jurisdiction need to satisfy itself whether the order under challenge is correct and whether the findings recorded in that order are legal and not perverse. So, if the order is perfectly legal, the court in the revision petition may upheld that order, and if the findings recorded in the order under challenge are perverse, the court in the revision petition may set aside that order. Whether the court in revisional jurisdiction has power to suspend, stay the execution of any order, and whether the revisional court can grant bail to the accused. In the revision petition, if the order is under challenge and the order is of sentence or any other order, the court has power to suspend the execution of that order or grant stay on the operation of that order. And if the revision petition is filed by an accused who is in jail, the court in the revisional jurisdiction has power to release that person on bail. What are the inferior criminal courts under Section 397 Cr.PC? For this, you need to see the explanation, which provide that the magistrates, whether they are executive or judicial, whether they are exercising the original or appellate jurisdiction, shall be deemed to be inferior to the Court of Sessions or the High Court. Whether a revision is maintainable against interlocutory order. If you see subsection 2 of Section 397 Cr.PC, it provides that the power of revision shall not be exercised in relation to any interlocutory order, whether that has been passed in appeal, whether in inquiry, trial, or any other proceeding. So now the question arises, what is interlocutory order? Whether all the orders passed by the inferior court in any proceeding are interlocutory, and how to check whether an order is interlocutory or final order, whether the revision is maintainable or not. The legal issue has been decided by the Supreme Court of India in the case of Amarnath versus State of Haryana, 1977, Volume 4, SCC 137, in which the Supreme Court has held that the interlocutory order merely denotes the order of a purely interim or temporary nature, which do not decide or touch the important rights of or the liabilities of the parties. But any order which substantially affect the right of the accused or decide the rights of the parties cannot be said to be interlocutory. And in that event, the power of revision can be exercised by the High Court or by the sessions judge. If an order is deciding the right of the accused, substantial right of the accused, and has any bearing on the trial, and if you think that the order prejudice the right of the accused or right of any other person, then that order is not always interlocutory order. That order may be final in nature, and you can file the revision petition against that order. For this, you need to see the nature of the order. The test is whether that order decides the substantial rights of the accused or the parties. And if you want to see the nature of interlocutory orders, you can see that many orders summoning the witnesses, adjourning the cases, and the order of bail are being passed by the inferior courts. Such orders are the interlocutory orders, and these orders cannot be challenged in the revision petition. Only the final orders or the orders which decides the important right or the liabilities of the parties are the final orders and can be challenged in the revision petition. What if a person has filed the revision petition before the sessions judge or before the high court, and that revision is dismissed by the high court or by the sessions judge? Whether that person can file the second revision petition before the next higher court? For this, you need to see subsection 3 of section 397 CRPC, which says if a person has filed revision before the high court or session judge, such person cannot file further revision petition. So, second revision is barred by the same person. Who is the same person? The person who is the revision applicant and whose case has been dismissed by the revisional court. But in case that revision petition has been allowed by the revisional court, then the aggrieved party against whom that order has been passed may prefer the revision petition to the next court, and in that event that party is not the same person as per subsection 3 of section 397 CRPC. If you think this video is informative and it discusses the scope of section 397, you can share this video, and you can also subscribe to my YouTube channel for more videos on legal issues.